इंसॉल्वेंसी और बैंक्रप्सी कोर्ट पर मुंबई में नेशनल कॉन्फ्रेंस का आयोजन किया जा रहा है। इसमें सेबी चेयरमैन अजय त्यागी और आरबीआई के गवर्नर उर्जित पटेल के साथ वित्त मंत्री अरुण जेटली भी शामिल हैं। आपको सीधे माला चलते हैं।
Alternative mechanisms that the RBI did create for the banking system, and these were intended to give the banking system a lot of flexibility in order to restructure the debts, in order to distinguish the sustainable part of the debt from the unsustainable part of the debt, to bring all the banking creditors together and frame a scheme by which effectively some realizations could take place. But these did meet with some success, but eventually I think it was still extremely difficult for the creditors to be effectively able to chase the defaulting debtors. If you look at the mechanism of the debt recovery tribunals which was created, it was intended that the court procedures took too much time, and therefore we must liberate these tribunals from the rigidities of the court procedure and enable our banking creditors, at least, or the financial institutions, to have a fast-track process. But eventually the debt recovery tribunals was somewhat faster, but not as effective as envisaged. I think for some period of time, the effective law which did serve a meaningful purpose was the Sarfazi law. And I do recollect, I was in the government at that time when the law was perceived in the year 2000 or 2001. And the overwhelming opinion was that it would be a per se unreasonable process. Unreasonable because our normal was that you have to wait till the cows come home in order to realize the debt. And here's a procedure by which you go on day one and take over after notice the assets of the debtor. Being a creditor, in our jurisprudence, was inherently putting you to a disadvantage. I remember the officer concerned in the expenditure ministry and I had then teamed up and framed and reframed the law, got it through a group of ministers, had difficulty in having it cleared by Parliament, had greater difficulty in having the challenge sustained before the court. And finally, I do remember from 12 or 13% very large NPAs, it did succeed in bringing them down radically over the next 2-3 years. So that was probably one exception to this whole principle, which proved to be effective. Now, when the IBC was perceived, there was a small group of experts, and the officer guiding them was Mr. Tyagi himself, and they went into long consultations and did draft this law, make repeated presentations. And much that Parliament comes in for criticism, I think this probably would be a record of some sorts that in December 2015 the law got introduced in Parliament. It got referred to a joint committee which sat almost day after day, presented its report in the month of May, that's within 3 or 4 months, and by in the month of March, I'm sorry, and by May we had the law in place. And May 2016 we had the law, and today, almost 15 or 16 months thereafter, we are now already discussing the last 9 to 10 months of the implementation of that law itself. I think this has significantly reversed the debtor-creditor relationship. And when I'm talking of debtor, I'm talking essentially of the defaulting debtor itself. To raise a debt is nothing improper. That's how businesses work. Now, the reasons for insolvency could be many. It could be genuine business losses because of a particular sector of the economy or some company getting into difficulty. It could be a case of mismanagement. It could also be a case of deliberate mismanagement, including some malfeasance on behalf of the promoters. And on account of multiple reasons, these insolvencies may occur. And I think now that the law has been put in place, the competent authority, the NCLT, has been constituted. We are taking special effort to make sure that the infrastructure there is also strengthened and brought in consonance with the requirements of this particular law. How does one make it effective? For one, there are strict timelines which the legislation has. And I think it's extremely important that these timelines have to be adhered to. Conventionally, Indian courts have always two standards. When timelines are read for the executive, they normally maintain these are binding. When timelines are meant for the judicial institution, courts have conventionally held that these are only directory. A typical case in point is, I remember as the law minister, I had amended the Code of Civil Procedure and put strict timelines. So pat came the judgment of the Supreme Court and said, well, courts will decide their own timetable. These are all directory, which are mentioned by Parliament. These are not mandatory on us. So I do hope these remain as mandatory as possible, and these timelines are adhered to, because that's really the essence of the law. Speed really will help in the effective implementation of the law itself. The creation of institution of the resolution professionals, because these are people from expertise in various different fields of finance, who are now going to be transformed into resolution professionals. They'll have to remain detached. They'll have to avoid any possible conflicts of interest. They'll have to be extremely objective. And therefore, when they step into the shoes of the management itself, it's their quality of professionalism which will ensure how quickly the resolution takes place. And it's not merely the resolution which will be the eventual target. It will also be as to what happens during the pendency itself. Now that is where there is a grey area, and in a grey area it's the judicial pronouncements which really resolve all the grey areas and then define them in black and white. A legislation is a skeleton structure normally. The flesh and blood to it is provided by judicial interpretation. And therefore the manner in which a company before the IBC during the proceedings is to be run, does its business come to a standstill? How do the normal operations take place? And I think the powers, in my own reading, under Section 17 and the subsequent paragraphs, clauses of the sections of the Act are absolutely clear. And if some purposive interpretation is given to them, the resolution professionals itself, by themselves or upon the direction of the tribunal, could be further empowered to make sure that the effective functioning of the company doesn't come to a standstill. Because if it comes to a standstill, then let alone resolving the insolvency, one will only be adding to it by allowing existing operations to themselves come to a standstill, and it's getting devalued over a period of time. And that is something which they will probably have to avoid. And therefore, you'll require an effective supervision as far as and directions to that effect as far as the tribunals are concerned. And therefore, the powers of the resolution professional itself will also have to be very clearly defined. There's a role of the Committee of Creditors which has been provided for, who has a direct and a positive interest in making sure that all those assets and businesses themselves are preserved. This is not the only law which we have changed. We've changed the procedures as far as the DRT is concerned. We've changed the provisions of the Sarfazi law, also provided for a very liberalized regime as far as the ARCs are concerned. And I think if we take the cumulative effect of of all these laws, the message now in the legislation is loud and clear that the debtors will certainly have to make sure that their debts are serviced. And if they don't do, there is an effective alternative mechanism by which you exit, or you take in a partner, and some alternative mechanisms by which businesses can be saved. The ultimate object really is not the liquidation of assets. The ultimate object as a preference will have to be to save these businesses, get either the existing promoters with or without partners, or new entrepreneurs to come in and make sure that these valuable assets are preserved. I think what is extremely important also is 9 months, maybe 9 or 10 months, maybe too short a period to have any knee-jerk reactions on what improvements are further required. We probably will have to wait over a period of time and then ensure as to how much of this law is made effective by various pronouncements of the tribunal, the appellate tribunal, and the courts which take place. And then over a period of time, I think what are the improvements in the law itself which are required to make sure that the purpose for which it has been created, I think is a purpose which is subserved. But one thing is very clear, that the old regime by which the creditor would get tired chasing the debtor and end up recovering nothing is now over. If a debtor has to survive, he'll have to service his debt, or he'll have to make way for somebody else. I think this is the only correct way by which businesses would now be done. And this message, I think, has to go loud and clear to all of them. I am extremely grateful to all of you who are here, because most of you would be somewhat directly or vicariously connected with this issue, and we'll be too eager to know from you as to what further evolution, either by a legislative process or by a process of judicial pronouncements in this branch of the law itself would be required. Thank you very much once again, Dr. Banerjee, for having me.